And the second lecture is going to deal with that essential, particularly in the area of errors and omissions, timekeeping, record keeping, and particularly in its relation to billing and accounting records. Ian White, your speaker, is eminently qualified in this area because not only is he a practitioner in a small firm where every record is important and every dollar counts, not that they don't count in the big firms, but those of us who are in smaller firms have to know where every nickel is, but also Ian was very active with the York County of York Law Association in connection with the discussions concerning what used to be known as our tariff. You now recognize it under a new name, Suggested Schedule of Fees. So all these things are now coming home to roost, and because we do have a good number of problems that turn up in Maltman's hands that might have been avoided or solved by good record keeping, good office management, good procedures, I'm very anxious, as I imagine you are, to hear Ian White.
Thank you very much, Miriam. I guess maybe I would change the emphasis slightly. I'm going to review with you the question of fees, billing, and record keeping. I must confess, when Miriam asked me to participate and then handed me the subject of fees, billing, and record keeping, my initial reaction was that that subject was about as interesting as watching paint dry. But after I got into the subject and did a little research, and particularly after some conversations that I had with Alan Marshall, I got quite enthusiastic about it. And I hope, notwithstanding the fact that you've all had a hard day and that it's almost 7 o'clock, that I can convey some of that enthusiasm to you. As Miriam said, I practice with a small firm in Midtown Toronto, and a major part of my practice is real estate. And I'm told that most of you practice with small firms in Toronto, and I'm sure that our problems concerning fees, billing, and record keeping are quite similar. Sorry. How many times have you been asked in a situation in which a client is in a crisis situation if you could recommend a good criminal or a good divorce lawyer? The public's recognition of the complexity of the services in these situations as a result of the crisis situation means that quality of service is the prime consideration rather than what's it going to cost, at least in the initial instance. In the practice of real estate, the situation is entirely different. Seldom in the initial stages is there animosity between the vendor and purchaser. There is seldom a crisis situation between the parties, and the client anticipates a simple transaction. The client's initial concern is therefore, how much will it cost, rather than a concern about the nature and extent of the service to be provided. Let me quote you from a recent article in a Toronto newspaper, in a Toronto magazine. It is not justifiable to spend a lawyer's time in simple matters like conveyancing. Whether lawyers like it or not, it is in the public interest to restrict lawyers to matters of great complexity where their fees are in fact justified. This kind of thinking represents a particular challenge to lawyers practicing real estate law. If we do nothing, we can only do ourselves a disservice and a disservice to the community. On the other hand, as I'm sure you all know, sometimes the challenge has been met by people streamlining their offices to the extent that corners are cut and service to the client deteriorates. Price competition has intensified in the last few years as a result of the development of a cost-conscious consumer and because of the number of lawyers that have been called to the bar. Price competition is a healthy condition in the marketplace to the extent that it increases efficiency of service. In the case of legal services, however, where the consumer often does not know exactly what to look for in comparative shopping, the result may be poor quality of service to the uninformed consumer. This state is dramatically evidenced by the alarming statistic that 55% of all negligence claims against lawyers come as a result of errors made in real estate transactions. That's 55%. I therefore believe that we must seriously address ourselves to 3 items. First of all, we must strive to operate our offices more efficiently by the proper use of paralegal personnel, the keeping of proper file and time records. Secondly, we must establish fair fees. Thirdly, we must educate the public as to the quality of service that they can expect. Now, the legal profession, through the Law Society and through the county law associations and the bar associations, assist us in upgrading our professional knowledge, training paralegal personnel, and in establishing fee guidelines. And they are also attempting more and more to educate the public. As Miriam said, the Law Society in June 1980 established a practice advisory service under the capable directorship of Alan Marshall to assist lawyers with office administrative problems. Now, what must individual law firms do themselves with respect to these items? First of all, we must strive to operate our offices more efficiently by, first, the proper use of paralegal personnel. The consumer cannot be expected to be paid for the time spent by a lawyer copying instruments from an abstract book, or for the lawyer sitting in a 2.5-hour lineup in the land titles office. The practitioner must identify the duties to be performed by paralegal personnel. Such services as title searching, preparation of abstracts, sheriff's office searches, municipal office searches, and ordinary closings can be performed by paralegal people. It's the duty of the practitioner, however, to train and supervise the work of these people. Nothing is more helpful than having competent paralegal assistants, and nothing is more frustrating than having paralegal people who are not given enough training and support to do their function. Secondly, we must strive to keep proper records. Keeping records is like paying taxes. It's a very painful thing to do, but the consequences can be very serious if we don't do it. The records are of 2 types. First of all, general file records and time records. With respect to file records, I would remind you that the courts are now holding lawyers liable in tort as well as in contract. A claim may emerge at any time, and a lawyer may be required to produce searches, certificates, and other evidences of title as long as the client owns the property. All lawyers are now also required to maintain a tickler or reminder system. And I can do no better than to read to you part of the bulletin put out by Mr. Marshall's Practice Advisory Service. And I believe that you have copies of this bulletin. When I read this, it really hit home. It appears that most lawyers deal with client matters on a response basis, that is, by responding to letters, telephone calls, etc. Our own memories seem to function best in sleepless early hours in the morning and malfunction, good intentions notwithstanding, with the first interruption upon arrival at the office. Consequently, we find ourselves responding to a client matter when motivated by some external influence or pressure. This is sometimes referred to as the crisis approach to the practice of law. The use of a reminder system to schedule a file by a number of entries in the system at the time of file opening should ensure that the client matter is handled effectively and without undue delays. The entry should schedule each anticipated step with appropriate advance warning of due dates or limitation dates. It should also include a scheduled or anticipated completion date with an entry shortly thereafter to remind of reporting, billing, and file closing. By thinking of the reminder system as a scheduling device and using your own imagination to apply the concept to your own areas of practice, you should be able to reduce many of the pressures of day-to-day crisis situations and reduce the risk of errors or omissions. Now you have in your in the workbook, I don't know, have they got it? Certain precedents. Initially, there is a file card. Obviously, if you're indexing a real estate transaction at the beginning, you index it under the client's name, and you index it under the property. Oh, I'm sorry, page 18. It's just after this buff-colored paper. Now, there are also reminder schedules, checklists, and there's also instructions to your conveyancer. I recommend those precedents for your perusal. When you open the file and you set up your tickler system, on the schedule will be the requisition date, a date for the receipt of a reply to the requisitions, a date for the receipt of a draft deed and statement of adjustments, etc., a date sometime prior to closing to be sure everything is ready for the closing, and if necessary to get the clients in, and a further date is scheduled for post-closing matters, reporting and billing, etc. As Mr. Marshall states in the bulletin, you must adapt these forms to your own office procedures and type of practice. Rule 2 of the Professional Rules of Conduct state that failure to keep and maintain proper search notes and failure to maintain an adequate tickler system constitutes service that is below standard. Now, with respect to time records, I'm sure you've all heard it has been said that the net income of lawyers who keep time records is about the same as the gross income of those who do not. Again, you have a bulletin from the Practice Advisory Service which talks about the timesheets, which you can have, which I suggest you carefully read. They're written in a very lively way. Time records serve two purposes. First of all, they accurately reflect the amount of work performed for the client. With respect to real estate transactions, if the amount of the fee has been agreed upon between the lawyer and client at the beginning of the service, the time records reveal the accuracy of the predicted fee so that the practitioner can either adjust the fee in consultation with the client or profit next time from the experience. Secondly, time records give the lawyer a clear picture of the extent to which he is generally making good use of his time. Time records are usually kept in 6-minute intervals or decimal one of an hour. This makes it easy to record items that take little time, but that should be acknowledged. Now, the second thing that individual lawyers and law firms must do, I believe, is to establish fair fees. First of all, let me refer you to the commentary attached to Rule 10 of the Professional Rules of Conduct. A fair and reasonable fee will depend upon and reflect such factors as A, the time and effort required and spent, B, the difficulty and importance of the matter, C, whether special skill or service has been required and provided, D, the amount involved or the value of the subject matter, E, the results obtained, F, fees authorized by statute or regulation or a suggested fee schedule of a law association, G, such special circumstances as loss of other employment, uncertainty of reward, and urgency. Basically, the fee in a real estate transaction is a matter of the exercise of the practitioner's sound judgment based upon his most valuable asset being time, multiplied by the hourly rate which reflects the practitioner's professional skill. Frequently, county law associations publish a suggested fee schedule which provides a point of reference for the lawyer, taxing officer, and the public. Prior to 1976, the County of York schedule was called a tariff, and the fee was based on a percentage of the purchase price. The word tariff suggested that a solicitor might be penalized if he constantly processed real estate transactions for fees below the set tariff. In 1976, the County of York Law Association and other law associations substantially changed the tariff with respect to real estate transactions. The changes were necessitated by certain conditions that existed at the time. First of all, the dramatic rise in real estate prices made the tariff unrealistic, and it was found from surveys that very few firms were paying any attention to the tariff even as a guide. Secondly, the amendments to the Combines Investigation Act called into question the validity of tariffs as they were then constituted. In order to arrive at the new suggested fee schedule, the committee attempted to analyze the work required to be done by a solicitor in an average real estate transaction. Discussions were held with the taxing officers, and legal firms were surveyed to obtain their reaction to the proposed amendments. Recognizing the infinite variety of problems that might arise in the processing of a real estate transaction, even though the dollar value is the same, a sliding scale approach was adopted. The resulting suggested fee schedule is simply a guide to the solicitor in finalizing the fee, and there is no coercion, direct or indirect, to adhere to the schedule. However, a fee substantially less than that suggested might indicate that some element of the service was being omitted. Few clients are sophisticated enough in real estate matters to judge this risk. This brings me to the third thing that I believe must be done by individual law firms to meet the present-day challenge, and that is education of the client. And I guess by education, I mean proper communication with the client. Clients often hold in awe the whole legal process and are reluctant to discuss the whole matter of services and fees. While I'll certainly admit this is not quite so prevalent in real estate matters, it is most desirable that there be mutual agreement and understanding between the practitioner and the client about the service to be performed, and the basis upon which the fee will be calculated should be frankly discussed with the client at the beginning of the transaction. Now, in a real estate transaction, it is also vitally important to explain to the client statement of adjustments, land transfer tax, and any other extraordinary items that the client may not expect and which should be included in the budget. One of my favorite examples is a offer to purchase between a purchaser and a builder. The purchase price is $63,000 and the mortgage being assumed by the purchaser is $55,000. The mortgage is therefore one that must be insured by the mortgage insurance company, and the purchaser assumes that he's paying the difference between $55,000 and $63,000 on closing, which amounts to $8,000, plus the legal fee, plus land transfer tax if he understands it. But without looking closely at the offer, there are a few things that he might miss. First of all, the offer says that the purchaser shall pay any mortgage insurance fee and mortgage insurance application fee as an adjustment. So suddenly there is based on a $55,000 mortgage, I believe that the premium is about 1.5%, so you're suddenly talking about another $800. Then you go a little further in the offer and it says the purchaser shall pay interest to the interest adjustment date. In other words, the builder is going to pay all the interest to the interest adjustment date, and the purchaser must reimburse him for what the builder will be paying on his behalf. Depending on when the interest adjustment date is in relation to the closing date, that figure could be anywhere up to $200. So we're suddenly, there's $1,000 that the purchaser wasn't aware of. Next, the offer says that the purchaser will pay interest on the unadvanced portion of the mortgage. The mortgagee always has a purchaser holdback, which will be advanced sometime after the deal's closed. And therefore, the builder not receiving the whole purchase price charges the purchaser interest on the unadvanced part of the mortgage. And it also says that the builder will be paying the real estate taxes, therefore the purchaser will reimburse the builder for the taxes the builder will be paying on his behalf. And the offer goes on to say that the builder will be entitled to estimate these amounts, and then when the final amounts are determined, to readjust. That, in my experience, that the builders usually estimate that figure at somewhere between $250 and $300. And then there's another little thing that the purchaser will pay for the establishing the water meter, which is $100 or $125. Suddenly you're up to $1,200, $1,300, or $1,400, which the purchaser had not anticipated. And you've all read articles in the newspaper. It says purchasers have to set up secondary financing to pay closing costs. The lawyer, being the messenger, is the one that always gets the blame. So I suggest to you that it is vitally important that at the earliest possible moment you go over the offer with the purchaser and apprise him of any of these extraordinary expenses. Now also, if there is any change or complication that may affect the client financially or otherwise during the processing of the transaction, he should be kept fully informed. Now, a word about timing at this point. Now, as anyone who has bought a house well knows, there is a multitude of unexpected financial demands involved in moving, quite apart from legal expenses. It is therefore important to both lawyer and client that major expenses such as land transfer tax, disbursements, fees for legal services be paid by the client along with the balance due on closing. Therefore, when the deal is complete, the account is paid. For a lawyer to operate otherwise is to unnecessarily burden his own financial resources and to invite the client to procrastinate in the payment of the legal account. One way to lose a client is if he has an unsettled account with you. Failing this arrangement, the final bill must be forwarded as soon as possible after the transaction has been completed, while the memory of the service is still fresh in the client's mind and before he or she is flooded by the many other expenses involved in the move. final bill should include a detailed account of the services rendered to act as a reminder to both the lawyer and the client, and if necessary, to withstand the scrutiny of the taxing officer. Because of present economic times, lawyers practicing real estate must become more like other business people. We must strive for efficiency, but not at the expense of quality of service. We must have a clear picture of what is the cost of quality service, and we must communicate this information to the community. We hopefully can then develop an informed and respectful public. Thank you very much for your attention.
Thank you, Ian. I must go back and check my tickler system. I know when you have that first interview with the client, it's terribly dismal. They go out kind of white, and all of a sudden you're the ogre because you've invented all these expenses. Brenda Duncan will tell you how nicely to avoid scaring your client on these points. That's coming up in weeks to follow. I would be very grateful if we could hear from Alan Marshall, Director of the Practice Advisory Service, and he and Ian may even want to have a dialogue here. I'll leave that up to you.
Thank you, Miriam and Ian. The Practice Advisory Service, as I hope most of you have read in recent issues of the Law Society Gazette and the Bar Association, briefly speaking, was set up to help members of the profession with their practices. That's a pretty broad statement. The need for the service was demonstrated primarily from two sources, and that one was the numbers of new lawyers who were setting up their own offices without the availability of a senior practitioner to give them some guidance and practical direction over some of the rough spots, so that I consider myself as a kind of senior partner to a lot of these people that have just recently opened their own offices. The other need was the demonstrated need for guidance on law office procedures, management, or your office administration arising out of the numbers of errors and omissions claims, most of which flow from just a breakdown in systems or a lack of systems. Now, I just want to comment quickly and perhaps elaborate on what Ian has read concerning the use of file or reminder systems for file scheduling. Lawyers generally react to three things: letters, telephone, and visitors. And when I say visitors, they can be internal, secretaries, other lawyers in the office, and so on, or external, clients coming into the office. So we generally react to those three things and respond accordingly. What most of us have been lacking is the fourth element that is very much needed, and that is reacting to ourselves. And the reminder system, or tickler system, if you will, is that fourth element. The tickler slip or computer sheet, whatever you use for your reminder system, is in fact a note to yourself to do something in the same manner as the telephone call, the letter from the other lawyer, or your secretary or whoever comes into your office. It is that fourth element. The tickler slip should come in to your office on the scheduled date, clipped to the file along with the morning mail, and treated as part of the mail. Some of it may not be important. You may be able to postpone, just as you do in replying to mail, hopefully not an important item. You schedule your day's work from that. Set aside some time to be sure every day that you can respond to the mail and your tickler slips. Now, on a real estate transaction, if I can just give you an example just to stimulate your imagination. When you're opening a real estate file, I suggest At that time, you should be writing to the client, and Brenda will be going over that with you, acknowledging that you have the offer and you're proceeding with the search. At that time, you should also schedule your file as you expect it to proceed, and also schedule reminders as you expect the client will be wanting to hear from you. For example, the client has made a note of the requisition date. There's something about 20 days they call about and say, you know, there was something about 20 days in the offer. I was just wondering about it. It's about that time. What do you do? Do I have to do something? What do you do? Well, if when you get your search completed and your letter of requisitions out, you just let the client know that you've looked after that, that's all part of communicating with the client, assuring them that you're on top of it, you know what you're doing, it builds up confidence. This is part of marketing. It's something lawyers do very poorly. There should be, what I'm suggesting is there should be a tickler slip in there, not only reminding you of the requisition date, but about 3 days before the requisition date, that the date is coming up. I also, in my practice, before I took on this position, had the tickler slip in about 1 week before the requisition date. So you've got 3 slips go in there concerning requisitions. When the letter of requisitions goes out to the other lawyer, at the same time, I let my client know by letter that my letter of requisitions had gone out. If there were some apparent problems on title, I would let the client know about them, some of my requirements. If there were only mortgage discharges and there were no serious problems, let them know that you had required some mortgage discharges. There seem to be no problems, and it appears that everything will be in order for closing. Then, about 2 weeks before closing, I would program the file to come back to me to check to see that I had my statement of adjustments. And if I didn't have it at that point, along with any required mortgage statements and other material, because I like to give my client 2 weeks before closing a complete rundown of all the finances, an explanation of adjustments, and a preliminary report on title. And if I didn't have it, I had a secretary who was very good at getting on the phone with the other fellow's secretary, and usually by the end of the 3rd day, she was tired of being bugged, and we got our response. So that at that 2-week period, it was almost a daily reminder to my secretary to keep bugging the other secretary until we had it. About 3 days before closing, the file would come back with the tickler card just to check the file, review it, make notes about closing requirements, and then, of course, on the closing date. A week after closing, I practiced in Hamilton for 25 years, and about a week after closing, we usually got our deeds and things back from the registry office within about 3 days. So a week after closing, there's another card comes up. It says, report to the client, send the bill out. That was usually done anyway the minute the deed came back, but it was just a further reminder. Now, if there were some undertakings involved on closing, they have to be scheduled. If it's a mortgage discharge you're going to be expecting, you have to allow the mortgage company maybe 3 or 4 weeks to get the discharge back to you after the closing date, but keep it coming up. In other words, let's stop losing sleep. Let's stop waking up at 5 and 6 in the morning and getting into a panic and then forgetting about it when we get into the office because other things arose. That's the basic concept. We have some question time.
Thank you very much, Mr. Marshall. If there are any questions, we'll be glad to accept them. From here on in, if you have any questions, would you be kind enough to write them out and send them into the Continuing Education Office, and we'll try and deal with them if it works out all right. This is not a very easy room for questions, but does anyone have one at the moment? Then we're sprung. See you next week.